Ladies and gentlemen, close your eyes for a moment and imagine this. A dying river, a dam, once hailed as the crown jewel of international cooperation, now reduced to a monument of mistrust. Two nations, Aramika and Botana, locked in a legal standoff, shouting over poisoned waters and broken promises. Now open your eyes because this isn't fiction. This is the very real future of international law on the brink. What happens when a treaty meets a tipping point? When environmental collapse meets sanctity of signed agreements? And most urgently, can international law keep up with a dying planet? Today, we explore the case that could redefine legal history. The Ramika Botana Dam dispute isn't just about a waterway, it's about whether the rules of yesterday can survive the realities of tomorrow. So, let's rewind. 10 years ago, the Ramika Botana Dam was a triumph of diplomacy. Two nations agreed to build and manage a shared hydroelectric project, a new era of regional cooperation, a symbol of trust. But fast forward today, the river has changed. Literally, rising temperatures, unpredictable rainfall, and upstream deforestation have transformed the ecosystem. Fish populations have collapsed. Water now flows sluggish, blackened, and toxic. Aramika blames Botana. They suspend the treaty, accusing Botana of over extraction, pollution, and violations of environmental standards embedded in the original agreement. Botana retaliates. They claim two things. The climate change has changed everything. What was signed in a good faith no longer reflects today's physical or legal reality. Access to clean water is now a human right, so fundamental that it overrides the dam treaty entirely. This isn't a simple breach of contract. It's a full blown legal earthquake, shaking the foundations of treaty law, environmental protection, international human rights, and so today we'll explore three seismic legal questions. Did Aramika have the right to suspend the treaty? Can climate change legally void treaty obligations? And has the global recognition of environmental rights elevated clean water to a just conscience norm, one that trumps all treaties? And finally, what does this all mean for the future of international law in the age of climate collapse? Let's step into the legal battlefield. A. Material breach. The damning evidence. Aramika's strongest card is the material breach doctrine under Article 60 of the Vienna Convention of the Law of Treaties. The law is strict: a treaty can only be suspended or terminated if the breach goes to the root of the agreement, not technical errors, not sloppy enforcements, but violations of severe that the purpose of treaty is destroyed. So Ramika has to show more than polluted water. They must prove intentional or reckless destruction of the dam's core purpose, cooperation, and sustainable resource sharing. They point to water toxicity level, ecological collapse, health crises in the downstream villages, and president must be cautious. In Gabčíkovo-Nagymaros, the ICJ held that environmental concerns, while serious, did not justify unilateral suspension. That case involved a hydroelectrical dam on the Danube, and the court emphasized that cooperation, not withdrawal, was the path forward. So, unless Aramika can prove systematic, sustained environmental degradation that makes cooperation truly impossible, they risk losing this argument. It's a high bar, and intentionally so. B. Climate change, the act of God defense. Now, Botana throws the 21st century's biggest legal curveball: climate change. They invoke Article 62 of the Vienna Convention, fundamental change of circumstances. Their argument, Your Honors, the river was signed about in 2015 is gone, the climate changed, and so did everything else. Sounds compelling, right? Well, not so fast. The ICJ in Fisheries jurisdiction and Namibia cases has constantly said the change must be unforeseeable. It must be radically alter the obligations. But is climate change really unforeseeable? Scientists have been warning us since the 1980s. IPCC reports, national action plans, and global agreements like Kyoto and Paris were all on the table long before this dam went toxic. That said, the scale of recent ecological collapse has been shaking. Even to experts, if Botana can present hard data, satellite images, declining river flow rates, biodiversity loss, erratic rainfall patterns, they might nudge the court towards accepting that the dam treaty's foundation has collapsed. If so, this case could set a groundbreaking precedent that the climate change isn't just an environmental issue but a treaty killer. But tread carefully. If climate change can unravel one treaty, it might unravel them all. Just cogents when water becomes sacred. Now come to the boldest claim yet. Botana says access to clean water is a just conscience norm, a peremptory rule of international law. What is just conscience? It's the nuclear tier of international norms, rules so fundamental that no treaty, no state, and no excuse can override them. Think prohibition of slavery, genocide, torture. Botana wants to add denial of clean water to that list. They cite the UN General Assembly's 2010 resolution declaring clean water and sanitation a human right. The UN Human Rights Council's 2022 affirmations that healthy environments are essential to dignity and life. They argue that poisoning a shared river isn't a legal violation, it's a crime against humanity. But here's the catch. While many agree with this sentiment, just cogence status is rare and hard to prove. There's no consensus yet. The legal community is split. Still, we may be witnessing the birth of a new just conscience norm right here in this case. The court could become a midwife to a new era of rights or remain a guardian of the older order. Now, let's dramatize this. You're on the bench of the ICJ. Three monumental decisions await. Is Aramika suspension legal? They show footage of dying fish, discolored water, and villages evacuated due to contamination. Is that enough? The law says yes. If the violation strikes at the heart of the treaty, but Botana's counterpunch is powerful, we couldn't comply, the river change. This is not a black and white case, it's a moral crucible. Obey the treaty and poison people? Or violate the treaty to save lives? Which one should we be doing? What does the law prioritize? Textual integrity or human survival? Let's find out. Can climate change void treaties? If the court accepts climate change as a legitimate excuse, it redefines treaty law. But are we ready for a world where every agreement has a climate out clause? If the court rejects this, it might uphold legal certainty. But at what cost? If it accepts it, we open the door to climate responsive legal systems, treaty law, treaty law that evolves with our changing earth. Is water the new human right to rule them all? Imagine in this case being taught in classrooms 30 years ago from now, 30 years from now, will students say this was the moment environmental rights became supreme? Or will they sigh the world wasn't ready and we paid the price? Is this the birth of eco jurisprudence or just a case that tried to fail? So, where do we go from here? A. The ICG's smart compromise. Instead of terminating the treaty, the court could invoke Article 62 and order renegotiation with climate experts at the table. This fosters accountability but also flexibility. B. The climate escalator clause. Future treaties need built in climate triggers. If temperature rises or water level drops, obligations must be reviewed. The Paris Agreement already does this. Why not expand the model to bilateral and regional treaties? And C, an environmental crimes courts. We have courts for war crimes. Why not one for ecocide? If clean water becomes just conscience, we'll need institutions to uphold it. Imagine a new tribunal where corporate polluters and negligent governments are held accountable for environmental devastation. Once radical, now responsible. In conclusion, this case is more than a dispute, it is a turning point. The Aramika Botana Dam has become a courtroom for the planet, a place where the past collides with the present and demands a new future. Can international law evolve before ecosystems collapse? Can treaties flex without breaking? Can we make justice flow like clean water for all? Aramika holds tight to Pacta Sant Servanda. Promises must be kept. Botana points to a drought-stricken river and says, adapt or perish. The ICJ is not just interpreting law, it is shaping our survival. And as the gavel falls, we ask ourselves, will we defend the law of yesterday or rise the demands of tomorrow? The river won't wait, neither should we. Thank you.